Hello everyone, my name is Giovanni Nogales and I'm a paralegal here at Liles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled An Overview of Recent Civil and Criminal Prosecutions Brought Against Texas Home Health Agencies, Hospice Agencies, their own owners, and staff. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box and we'll address as many as possible at the end of the presentation. So without further ado, I present your speakers, Robert Liles and John Pierce.
Thank you so much, Gio. This is Robert Liles, and I'm the managing partner here at Liles Parker. I was an assistant U.S. attorney for a number of years and served as the National Healthcare Fraud Coordinator for all the U.S. attorneys around the country. And I'm really lucky today because I've got my partner, my law partner, and also friend, John Pierce. And John is, he has a resume that is just, it's hard to beat. He was a prosecutor in San Diego. He was a federal prosecutor in San Diego. He was a federal prosecutor in D.C. And when I met John, he was a federal prosecutor in Alexandria, where he also served as the healthcare fraud coordinator for the office and the proxy for serving on the Attorney General's Advisory Committee. So John was there with the other U.S. attorneys that were on the Attorney General's Advisory Committee, and he was involved in a lot of the initiatives and a lot of the formulating the plans for moving forward with DOJ and healthcare fraud. And I know, John, that you just got off of a 5-week healthcare fraud criminal case, didn't you? In trial.
Yes, it was.
And that was really something. So today we're going to talk about what's happening in Texas on the civil and criminal side, but I would be remiss if I didn't bring up the elephant in the room. And the elephant in the room, of course, is the administrative cases that are being pursued against home health and hospice, primarily revocations. And that's something that it's a different animal than what we've seen in the past, which in the past was almost always a suspension action. But we'll get to those. Okay, so let's talk first about the False Claims Act, John. I know you've done a lot of False Claims Act cases over the years. They were really touting the fact that they brought in so much money, $6.8 billion, 5.7 of it was from healthcare alone. That's just amazing, isn't it?
They certainly have an emphasis on healthcare when it comes to enforcement actions. You can bring False Claims Act cases for any claims that were wrongfully submitted to the government. So, for instance, government contracts. There could be a enforcement, both criminally and civilly, and false claims for government contracts. But it's healthcare where they focus most of their energy and efforts with this administration.
Which is really interesting because when I first started as an AUSA, as a prosecutor in Houston, in the Houston office, at that point, of course, healthcare was part of what we call the ACE program, Affirmative Civil Enforcement. And that included everything from food stamp fraud to healthcare, right? In those days, of course, it was bank fraud and drug cases, the OCDF program, that was really the 800-pound gorilla in the room. That's where all the efforts were going. And it wasn't until they passed HIPAA in August 21st, 1996, that healthcare really kind of got some teeth. And that's when they brought me to D.C., was as the coordinator for that program. But if you look at these numbers on the screen here, John, it's really interesting to me. We had a new record, 1,297 key tams. Wow, that's a new record ever. And what does that mean to you, other than the fact that the False Claims Act now is something that is well known, and literally every person listening on this call, whether you're an owner, an operator, or an employee, everyone on your staff is a potential whistleblower.
Well, a whistleblower or key tam case, of course, is when somebody jumps in the shoes of the government and brings an action alleging that there were claims and usually payments made by the government for conduct that the whistleblower believes is wrongful and illegal. So it is the whistleblower who initiates the lawsuit, and that gets filed under seal so that the government has a chance in secret to conduct its own investigation, because it is a loss by the government that's being alleged. So the government has a chance to take it over, intervene, and then the claim will be unsealed. However, even if the government doesn't intervene, the law allows for the whistleblower to proceed and recover money, again, on behalf of the government, but entitled to a cut. The whistleblower would.
And what kind of cut is that?
That's depending on whether the government intervenes. It typically varies between
15 and 25?
15 to 25 or 29%, thereabouts.
Yeah, okay. And if the government doesn't intervene, they can get up to 30, I believe.
That could be, yeah.
Okay. All right. And this is also interesting all right, so of the $5.7 billion, it's important to recognize that most of that money came from cases filed by whistleblowers. But not to, I don't want to leave them out. This, the folks at DOJ attorneys, what they mean there is, they're in Houston. They've got a civil coordinator in the Western District. In San Antonio, they have one. In Beaumont, they have one. And in Dallas, they have one, right? Between those guys and the civil fraud attorneys, around the country, they filed 401 of their own cases. So, it's not everything is being filed by whistleblowers, but most of the cases are.
That's right. And then, like I say, the government has a chance to intervene and take over the case. But the reason that we have the increase is just because that many more people know about the opportunity to bring claims when they see wrongful conduct.
That's right. Next slide. Okay, so under the False Claims Act, just very, very briefly, I know that we have a very sophisticated group on the phone. We're not going to have to go over this in a lot of detail, but if you knowingly submit or cause to be submitted a false claim to the government, you can be liable. And knowingly, of course, is quite broad, isn't it? It's not just actual knowledge; it's also reckless disregard and deliberate ignorance. It's got a long statute of limitations. 6 years or up to 3 years after the government learns about it, up to a maximum of 10 years. And how does that compare to most criminal statutes, most criminal federal statutes? What's the statute of limitations for most criminal federal statutes?
Most of them are 5.
5 years. Now, of course, with bank fraud, it can be up to 20 or something like that. It's crazy numbers, right? But most of them in healthcare context are 5 years. That's right. I would like to point out these numbers too. We've been doing this so long, John. We remember when the potential penalties were $5,000. Remember that, $5,000 to $10,000. Well, they passed a statute. I don't know how many years ago now. It's been quite a while that adjusted those numbers. So you'll still see a lot of books and the rest of it that talk about between $5,000 and $10,000. But when you actually increase it with the cost of living increases, as of last July, it's between $14,000 and $28,000. What that means is, for every false claim, if the government were to go forward and prove it, not only do they get 3 times the damages, but they also get between $14,000 and $28,000 and change per false claim.
And that could be a claim for $300 that turns into a penalty of $11,000 or $14,000 and more.
And that's one of the reasons why these cases, of course, are never really tried, because it's like the sword of Damocles hanging over an organization's head. If they lose, it's bet the farm litigation every time.
That's right.
Next slide. Now, this is your sweet spot here. Now, what can you tell me about this? What do you think about these numbers, John?
Well, what it shows us is that as I was saying earlier, there are many ways that there could be false claims submitted to the government for the government to recover for wrongful conduct. But the primary focus is in the healthcare area. There's more activity there with the government than anywhere else.
And it's really interesting because these numbers that we have on the board here, guys, this is just for the DOJ fraud section here in D.C., okay? This does not include all of the criminal healthcare fraud prosecutions coming out of Dallas and Houston and San Antonio and Beaumont. But it shows you, though, that it really is amazing how things have changed. When you and I first worked together, of course, it was, or in the very beginning, we go back to the 90s, like I said, it was mostly bank fraud cases, but these and Foreign Corrupt Practice Act matters, but not anymore. Now it's healthcare. That's the game that's being played. Next slide. Okay, the anti-kickback statute. Now this is one. There are a dozen different statutes that you guys have potential exposure under if you are running a hospice or a home health company. But the primary ones, though, on the civil side, of course, are the False Claims Act. On the criminal side, the primary statute you have to worry about typically is the anti-kickback statute. And why is the anti-kickback statute so egregious?
Well, part of the way that it's egregious, and the reason that it's focused on in the home health industry is people that go out and, let's say, we call it mining for bodies, trying to find bodies to fill beds that wouldn't otherwise qualify for the coverage. So the idea in healthcare is that the doctor makes a decision independent of any influence about whether care is needed. And if instead people are kicking back money to the providers, whether doctor or home health agency, to generate care that the government pays for that's not necessary, that's why the conduct is egregious in the eyes of the government.
Now, essentially, let me make sure I've got this right. Under the anti-kickback statute, if you provide any type of remuneration, and that's a crazy word, right? But it means anything of value, basically, in an effort to induce a referral, that would be a criminal violation. Is that correct?
That's right.
That's right. And it's quite broad because you don't even have to know that you're actually violating this law, but you can still get in a lot of trouble. Next slide. Okay. One thing to point out just real quickly is that when they passed Obamacare, they included a specific provision in there that said that criminal violations of the anti-kickback statute can also be pursued as a violation of the Civil False Claims Act.
Yeah, so that's called a parallel prosecution, and the real key here, and when it comes to the healthcare context, is that any conduct that could violate a civil law can also violate a criminal law. It may depend on the level of intent, but you don't have to intend to violate the law. You just have to intend to commit the act.
Yeah, and in these cases, like in Texas, for instance, we've seen a lot of cases, haven't we, where they were settled under the Civil False Claims Act, but it was really bootstrapped off of an alleged violation of the kickback statute. So the government decided, for whatever reason, they're not going to pursue these claims criminally, but they are going to go after them under the Civil False Claims Act. Next slide. Now, one thing to kind of point out, John, the anti-kickback statute is so broad. It's really embarrassing it's so broad. In fact, it's so broad that they had to kind of carve out these things that they call safe harbors. And they said, there is conduct out there that under the technical read of the statute would be illegal. But we're going to say that if you have these certain safeguards in place, these bumpers in place, that we will not consider that particular conduct to be a violation of the criminal anti-kickback statute. And there's so many of these. There are 11 that Congress has passed, and there are 36 that OIG has done administratively through the Federal Register. So, that's 47 safe harbors. There's almost more exceptions to the rules than there are the rule, right?
Well, except that there are a lot of safe harbors that seem like they're safe harbors, but they're safe harbors in disguise.
So. Well, and we're going to talk about those. That's a very astute point. Next slide. For hospitals, for hospices and for home health, my experience, and yours too, has been that there are two primary safe harbors that come into the picture a lot, okay? There's a personal services and management contract safe harbor and the employment safe harbor. And we're going to talk about those because when it comes to medical directors and when it comes to your marketing sources, your marketing people, regardless of what you call them, whether it's a marketer or a community liaison or whatever it is, those guys, you got to be very careful. Next slide. All right. Let's talk first, I guess, about the employment safe harbor. The employment safe harbor is one that essentially under the employment safe harbor, if you meet certain requirements, then, in fact, you can pay someone however you want to pay them pretty much. I mean, the government doesn't like, let's be real clear. I've seen situations where an individual qualified as a bona fide employee, but they were being compensated based on, their success in drumming up referrals, okay? The government doesn't like, even with employment situations, they really don't like compensation schemes that are based on or that vary by value or volume. They just don't like them, okay? But it's not technically illegal if you actually meet the requirements of an employment safe harbor. Next slide. Here is an interesting case. This is a DME case, okay? And what was happening was the DME company was paying the marketers a commission, okay? And, the problem, of course, is if they're not a bona fide employee, then they don't meet that safe harbor for the employment safe harbor. And as a result of that, then, it's illegal. Here's what happened in this particular case. The marketers, here's what the analysis that the court went through. The marketers did not get regular paychecks. The payments were made for referrals only. There was no evidence that the DME company owner provided any training or direction to the marketers. There was no evidence that the marketer ever received any payments from the DME company to advertise or market. In other words, the DME marketers basically had to pick up the tab, their gas money, their car, all the rest of it, to go around and try to drum up referrals from doctors, right?
So the issue with the government is that the government wants there to be a personal relationship between provider and patient. And they don't want a third party, an intermediary, a marketer, if you will, who is drumming up business for services that aren't really necessary, but they're just trying to, increase their own pay. And that's why payment in this area to marketers on an incentive basis is the problem. If somebody's on salary and all they're doing is finding people who need the care, and there's no incentive, and they create a proper provider-patient relationship where the decision is made by the patient and the provider instead of by a marketer, well, then it's going to be okay. And let me just tell you where to be careful in this area is that you're always going to be approached by marketers who say, here, I've got an agreement and we can work together, and don't worry, we're in the safe harbor, and I've already had my lawyer look at this, and so here's our agreement. And it may say that it's being paid on an hourly basis, but then what happens is that, they just calculate the number of hours based on, the number of people. So it's really incentivized, and it's just an employment arrangement in disguise.
And the government actually looks at that more critically because they think you are actually trying to subvert the law.
That's right. So the moral of the story here is when you ever get approached by anyone with an agreement where they tell you, well, our lawyer's already blessed this, you can just sign it. Get your own lawyer to look at it because a lot of these arrangements are just safe harbors in disguise.
Yeah. So let's just talk about the two flavors real quick about marketers, okay? You can have an employee. If the person is a bona fide employee, and we could do a whole presentation just on that, understand it's not the factors that the IRS has. They're similar, but they're not exactly the same. The Supreme Court has actually come out and said, these are the factors. So there's like 18 of them that they look at. But it is things like, do you provide training? Do you pay their expenses when they're out marketing? How are they being paid? Who do they report to? All that kind of stuff. The mere fact that you're taking out taxes and giving them a W-2, that is not determinative of whether or not they're an employee. So be very careful, okay? Be very careful. But you can, if they are a bona fide employee, you can reward them based on their productivity. That's the American way, thank goodness. If they're not an employee, if they are a mere contractor, okay, and they're getting a 1099, you cannot pay them in a way that varies by value or volume, period. That is against the law. Be very careful. Okay, next slide. Now let's talk about the personal services agreement. And where this comes in primarily is medical directors, right? That's it. And we got a whole slide talking about medical directors later on. But the important thing here is, when's the last time you looked at your medical director agreement, guys? I have to tell you, if you haven't looked at it in the last few years, you need to have a qualified health lawyer check that thing out. And part of the reason I say that is, this is something that again and again, the OIG has issued special fraud alerts on medical director arrangements. And they're actually, we've got cases right now where the government has issued to our clients a civil investigative demand, and the first thing they want to see is, where do they get their business from? Where do they send their business to? And in many cases, it's medical directors that make referrals. Now, in a perfect world, John, you would have a home health agency that employs a medical director, and in fact, that medical director doesn't send them any referrals at all. That's the cleanest possible imagined or situation you could have for a medical director, okay? But unfortunately, that's not real life.
They usually come from outside, somebody who's in the industry and familiar with the industry. That's what helps make them qualified as a medical director. But what the government is going to look to is that if the number of hours that it takes for a medical director to do his or her job with the agency is, let's say, a normal an hourly rate would pay $5,000 a month, and this person's getting $20,000 a month. The government's going to consider that agreement a ruse, look behind it, and find that, oh, well, this guy's sending all of their patients. So again, it's almost like a disguised safe harbor, some of these agreements. Just be very careful with whatever arrangements are being made with the medical director.
Yeah, and we're going to talk about medical directors specifically in just a few minutes in more detail. Next slide. Okay, so where are our home health and hospices? How are they coming under the microscope of the government? Well, frankly, in Texas, it's the UPICs that are looking at them. Okay, the UPIC is doing a lot of audits, but it's not just the UPIC, because of course we're going to talk in just a minute about the PPEO audits that we're dealing with on the hospice side and how active that is. But the fact is, we talked about early on, a lot of these cases, of course, come from whistleblowers, but the ones that aren't, on the audits and investigations, the UPICs and the SMRCs and the MACs, they have a lot of data, and they can slice and dice that data so many different ways to identify outliers, and that's exactly what they do.
Yeah, in all of healthcare, the government looks at data for outliers, and if somebody sticks out more generating more revenue or number of patients or whatever it is, if that's
or types of patients, yep,
if it's off the chart compared to the rest of the people in the industry in the region, the government's going to take a closer look.
Okay, next slide. Just very quickly, I would like to point out that in Texas, DOJ set up these strike forces years ago. Texas is the one area that has 3 different strike forces that they've established and set up. I mean, it's very active in Texas. They're looking at a lot of things. Opioids, one area that they're looking at, of course, but that's not all. So, be very careful. I mean, Texas is an active area. And of course, as we've talked about before, for our friends down in the Valley, even though Florida is recognized as like the epicenter of healthcare fraud, if you will, the highest per beneficiary expenditures for Medicare in the country are in the Rio Grande Valley. And, if that's where the money is, that's where the government's going to look. Next slide. Okay, the Yates memo, just very quickly, we've talked about this a dozen times, so I don't want to beat this horse to death, but the fact is that this is something that has bled over to the current administration, and it went through Trump 1, and it's gone through the Biden years, and now we're in Trump 2, and DOJ's position really has been modified over the years, but it hadn't really changed. The government is going after individuals, aren't they, John?
Yeah, it used to be in the old days that if there was wrongful conduct within a corporation, for instance, that the defense could negotiate with the government and say, oh, well, the corporation will plead guilty and pay a huge fine, and the government makes it look good for the government that they got a bunch of money out of criminal or civil enforcement action. But it just meant that the officers who were responsible for the conduct were getting away with activities that, people in other areas were not getting away with and were being held personally accountable. So there was a shift that when there is fraudulent conduct, you can't hide behind the organization. We want to find the individuals responsible for it and hold them accountable.
And that makes sense, because technically a corporation can't violate the law, right? It's a person in the corporation that violates the law.
Well, corporations are defined as persons, so that's how they got away with it for a while. But that's right. They're not making the decisions. The people are.
Next slide. All right. Now, we've talked some about the civil and criminal statutes. We'll talk a little bit about those cases in a minute. But one area I just didn't want to miss, though, is the fact that the administrative remedies these days have just gone through the roof. CMS has gotten very, very active, and they're doing, and their contractors are doing a lot of things that we hadn't seen in the past. In the past, of course, we've seen things like, prepayment audits, post-payment audits, those types of suspension actions, lots of suspension actions in the past against home health and hospice, right? These days, though, they don't even bother with a suspension action a lot of times. Instead, they're going straight to a revocation action, okay? And that's where we're going to talk a lot of time on is revocations. Next slide. Now, revocations, let me just do a little bit of history. If you go back to 2003, they didn't have much in terms of statutes, the statutory provisions for revocations and the reasons that CMS had to revoke somebody. It wasn't there. The only way you could really be revoked was if they terminated your agreement because you did something in violation with your provider agreement, or there was a conviction that resulted in exclusion. Then they could get rid of you that way. But starting in 2003, they started proposing new ways to revoke someone's billing privileges, right? And that takes us all the way up to today, okay? They had actually more changes that they proposed last year that went into effect this year on January 1. So now there's like 18 or 19 different reasons that a home health or hospice could have their billing privileges revoked. And in fact, it's interesting, they just put it up in February. The latest numbers are from the end of December, but there are currently 7,465 individuals and entities where CMS has revoked their billing privileges. I'm not talking about ever. I'm talking about today. They have an active bar against enrollment. That's bad. And the other thing is, in the beginning, when they first did this, up until 2023, if they did revoke your billing privileges, John, it was only between 1 and 3 years. When they changed that in 23, now it's 1 to 10 years. Oh my gosh. That can put you at, that's more egregious than if you had a criminal conviction. It's probably only going to be 5 years in most cases. So this is really rough. Next slide. All right. So let's talk about some of the ways that they're revoking. And I've tried to highlight the ones that we're seeing mostly with home health and hospice. One of the ones that comes up a lot with home health, on-site reviews. Okay. The UPIC or the MAC will send out somebody, and they will show up. And when do you think they show up, guys? Around noon. That's the time they show up. And they knock on the door at noon. Well, what happens at noon? People go out to lunch, they lock the door, and they leave. If they don't find somebody in that office when they show up unannounced, then they will immediately send out a letter to revoke you, because they take the position, well, this is some kind of, it's a sham office. We don't even know if they have real patients, because they're not operational. They're supposed to have posted hours, and they're supposed to be there during the posted hours. So on-site review, this is one that we primarily saw almost always for revocations with home health. Lots and lots of that. Okay, that was a big one. Next slide. Now, but you can see all the ones these are all the things that they've added over the years. Non-compliance with enrollment requirements. If anybody's convicted of a felony, conduct, exclusions, debarments, and the rest of it, false information, and other types of things like this. Okay, next slide. Okay, abuse of billing privileges. This is the new area, the one that we're so concerned about. And this is the one that they're going after and they are revoking hospices in Texas. We have probably half a dozen or more revocation cases out of California alone where they have revoked the hospice's number based on this abusive billing privileges provision. Specifically, what they say is that there is a pattern or practice of bad billings. Okay, and that's all under the PPEO project, and we're going to talk about that in just a second. But this is really important, guys, because the revocation process, the administrative appeals for it, it's really tough, really, really tough. Next slide. Okay, these are some of the, I didn't want to leave it, not listed. These are just the other reasons that they can revoke your number. There are certain adverse actions, like if there's an adverse legal action at your home health or hospice, or there's a change in ownership, if you don't tell them, or you have an addition or deletion of a new location, if you don't tell them within the required period of time, 30 days, they can revoke you for that. Next slide. Okay. Failure to document or provide them access to documentation. We haven't really seen this happen with home health and hospice. It does happen a fair amount with doctors' offices where they just, these people will show up, and half the time what happens, of course, is the practice is so scared about HIPAA, they don't know who these people are, and they're not government employees, and they've got some card from a UPIC that they've never heard from before, and they want to come in and they want to start looking at records. No, so they don't let them. And when they don't let them, next thing you know, they get revoked. Next slide. Okay, other program determination in reserve operating funds. That A11 could come up with home health and hospice, but well, really home health, but it's not something that we've ever seen them do. Next slide. Prescribing authority, improper prescribing practices. That's really doctor. We haven't seen that with you guys. Next slide. False Claims Act. Okay, this does not mean that if you settle a False Claims Act case that they're going to revoke you, okay? But it does mean that if there is a judgment under the False Claims Act, okay, that's where, you didn't settle it, you went to trial, they got a judgment against you, they can revoke you for that. They can revoke you. All of these, of course, are permissive. They're not, except for perhaps the exclusion provision, but the rest of these are fairly permissive. Next slide. This is interesting. Debt referred to the Treasury. That happens all the time in overpayment cases, right? But there's an exception when the case is under appeal. Guys, I don't care if it's one claim and it's only worth $200. If you, in fact, provided those services and they were medically necessary and you got the documentation, please exercise your appeal rights, because every time you don't, it increases your error rate and it makes you a bigger target. Okay. Revocation under a different name and business identity. This is situations where somebody gets in trouble. They have their billing privileges revoked, and they either set up a new company and have a sham owner, or they hook up with another company, and they move all their patients over. You got to be careful. That can get them revoked too. Next slide. Non-compliant location. Yeah, that's one that's not registered really if in the context of a home health or hospice. Abusive ordering, certifying, referring, and prescribing. That's not really going to hit you guys, but it could very easily hit your medical directors. Next slide. And then, supplier standard or condition violation. That's not y'all. That's for DMEs. So that's, we're at the A23. Now, there's a couple reserve provisions in there, but you can see we went from almost nothing addressing revocations in 2003 to 23 years later, and we have this whole panoply of reasons that they can pull your billing privileges. Next slide. Okay. Yeah, that's the same one. Yeah, that's the same one we just looked at. Okay. All right. Now, the PPEO audits, guys. For those of you, and right now it's hospice, okay? But just like the TPEs, where'd they start out? Well, they started out with home health. Now, not that many home health agencies have them going anymore in Texas. Now it's everybody else. They're going after the regular docs. the regular practices, the DME companies, everybody else. So the mere fact that the PPEO has started out as a hospice audit initiative does not mean that's where it's going to remain. They will take these same ideas and they will apply them to home health as well. So who does it impact? Well, technically, it was only supposed to impact newly enrolled hospice agencies, okay? And they were concerned about, these fraudulent agencies popping up all over the country. Guys, y'all seen TVs like I have. What's that young man who's going around and finding all the home health agencies in Minnesota and they don't have anybody there at the offices? Nick Shirley. Yeah. So they were concerned about this before Nick Shirley, but this is what Nick Shirley's looking at now. Okay. The problem with their definition of a newly enrolled hospice is not just a new hospice. Okay. It's also one that has changed ownership. Wow. That's a problem because many of the folks on this phone, you have bought a hospice from another company. Well, technically now, that is a new hospice that is going to be subject to audit under PPEO. And this is a real problem because what's happening is they will pull like 10 claims. Not even something that, at least with a U-pick, you're going to see something a lot broader, right? They'll pull a handful of claims, and then based on that, if they come back and they say 4 of the 10 are no good, they're taking the position that is an abuse of billing privileges because it constitutes a pattern or practice, okay? So they're revoking it, all right? Now, that's a real problem, guys, because when they revoke the billing privileges for that hospice, for those of you who bought a hospice, okay, and now that hospice has been revoked, then they're turning around and under the affiliation rule, they're then looking at every other hospice that the company owns and they're going after them too. So this is a company killer, guys. If you have a PPEO audit and they're still going strong in Texas, if you get one of these requests, don't try to respond alone. Get your health lawyer involved, okay? Before you send the documents in, try to put your best foot forward from the very beginning, okay? All right, next slide. All right, so here's in Texas, these are the primary reasons for denying claims, okay? 43% of the documentation doesn't support the prognosis of 6 months or less, all right? 14%, they didn't return the records timely. You cannot ignore this. This is not just your standard, peanut butter jelly audits, okay? It's not a cert audit, okay? This is something very serious. Billing errors, 10%, face-to-face problems, 5%, and the physician narratives not present, not valid, 5%. This is what today, what Palmetto is saying that they're denying claims on primarily. Next slide. All right, so what should you do? John, what should you do to get ahead of this in the future?
Well, always best to get your healthcare lawyer involved to make sure that you're in compliance with everything to avoid the pitfalls of these audits.
Yeah, you do. And, all of you, especially in Texas, if you're signed up for Medicaid, one of the things that's required in Medicaid in the Texas Participation Agreement is you have to swear not only that you're screening everybody every 30 days for all states, not just Texas, but you also have to have an effective compliance program in place, okay? And what's one of the most important elements of the compliance program? Internal auditing and monitoring. When's the last time you've gone through and pulled your own stuff, your own files, your own records, and looked and made sure that, in fact, they qualify for coverage and payment? Especially on the hospice side, it can be very tricky because, of course, depending on the diagnosis, you have different requirements, right? So, be careful. Be careful. And if you've learned the PPEO audit, don't wait till the last minute to contact your attorney. You really have to be on top of that, right? And the affiliation rule, don't forget about that. Early on, you've got to talk, and that's another reason why you have to talk to your attorney, because if, in fact, you're facing a possible revocation, you may have to divest interest in other companies so that they don't get tainted as well. Very dangerous. And of course, if the affiliation rule, my partner down in Houston is the one you need to talk to, Jennifer Papafana go to, or my partner in Dallas, Heidi Kocher. Those are the ladies that really do a lot of this affiliation question issues. Next slide. All right, hospices. Okay, TPE audits, they're going on, but not really much for hospice in Texas anymore. Those are they could still happen, but it's not really happening much. Now, this review choice demonstration project, it was very active in Texas. It's still technically active in Texas if you look it up. Once again, though, we haven't seen those in a while. They're kind of quiet. Haven't really seen a lot of them going on. RACs for home health, they are active for home health. We haven't seen any RACs for hospice audits, but home health, there are still some RAC audits that are coming through. And the primary issues the RACs have been looking at, of course, is medical necessity and face-to-face. Next slide. I think that's the same slide. Okay, all right. These are, when it comes to UPIC audits are still going strong, right? These are the primary reasons for denial for UPIC audits, all right? Homebound, still an issue. No skilled need, something pops up all the time. Face-to-face is missing or untimely. The certifications, research are bad. The plans of care are inadequate. The documentation doesn't support eligibility. You know, guys, you got to look at it. Late or missing wraps, you know, for older periods, and then OASIS inconsistencies. You know, there's a mismatch between what you've got down in the data and what you're billing for. Next slide. Okay. UPIC audits for hospices. Okay. Similar type reasons, I suppose, in terms of, you know, documentation. Untimely or missing certification of terminal illness, the defective face-to-face. This is a big one right here. Invalid election statements. Guys, this is something that the government is very concerned about. They're very concerned that when people are signing up for hospice, that they're not really being properly advised that when they sign up for hospice, they are essentially foregoing all curative care, that everything that they're going to be getting is going to be palliative, okay? So you got to be really careful. Also, I can tell you that we've got several cases right now where there was an election statement in the file that the client put together, but it didn't have all the necessary elements because, you know, they've made some kind of tweaks to that over the last 5 or 6 years. So check out your election statements. Make sure that they're compliant. Really, really important. Okay. Incorrect hospice level build, lack of support for terminal prognosis. Once again, it really goes back to, and this is one where they're kind of tricky, aren't they, John? Because they will say, we want to see the support for this particular period, you know, this 30-day period. But the fact is, you may have to, even though they're limiting their picture to that 30-day period for the audit, you may have to also, on your own, include some earlier information there so that there's no question that the prognosis supports the terminal illness.
Yeah, like they say in healthcare, if the documentation isn't there, then the services weren't provided.
That's right. That's right. Okay. What do you think about these cases that are taking place? I mean, the good news, to the extent that there is good news, guys, in 2025, there were not a lot of reported criminal and civil settlements or criminal convictions, okay? But that doesn't mean that the cases aren't active and ongoing, because I know we're defending some of them right now. So you got to be careful. But you remember last June when they had that massive takedown? Yep. Well, the 22 of those cases were out of the Southern District of Texas.
And they take a while to get through the system, but they're going on.
They are. Okay, so I will say, guys, you know, once again, whether you're home health or hospice, if you are audited by the government, you know, and it's either a False Claims Act case where you would probably get a civil investigative demand or maybe you might even get a subpoena, okay? So we're not just talking about just a UPIC audit. We're talking about something more egregious than that. You know, what we've seen is ultimately at the end of the day, they want to know where are you getting your patients from, right? And how are you getting them?
Yep.
Okay. All right. I want you to talk about these common deficiencies that have been noted in Texas.
In terms of hospices and home health?
Yep.
Well, you've got terminal illness certifications and recertifications that are that documentation is missing. They find referral relationships that are improper. The beneficiary is being given false information about services being rendered, and then medical director problems where the certifications don't match the need. And then with home health agencies, you've got problems with the eligibility of the homebound status. You've got records that are insufficient for the services being provided, lack of record integrity. You've got the assessment of timing and documentation consistency, where you've got cloned records, late records, they don't match, they're not being, the files aren't being updated properly and timely. And then certainly if there are any false certifications of medical necessity, that's another thing where the government's always going to take a close look.
Now, you talked a lot about records there, with late records, cloned records, contradictory, and all that kind of stuff. You know, what do you think about, I mean, I just spoke at a conference not that long ago, and it was a big conference, and they had a healthcare course, and they had lots and lots of vendors. Every vendor table and sign, they were all hawking the same thing, saying, if you use our system, we now incorporate artificial intelligence.
You know, it's interesting when it comes to medical records, because if a provider provides the same services and they have a template that they want to use to describe those services and not be bogged down by administrative work, then you know they ought to be able to do that. But then that's where the government says, well, that's not individualized to the individual. So I don't know where AI is going to take it, where it's going to actually understand and distinguish between services provided from one patient to another. But we're in an interesting frontier.
We are. And I stopped and talked to a bunch of them, and I asked everyone the same question. I said, well, that's very interesting that you're incorporating AI. Oh, yes, it's just wonderful, and it really saves them time, and it can populate this and do this and all this kind of stuff. And I said, well, how have you factored in the fact that DOJ, okay, it was under the Biden administration, but it was a couple of years ago now, has publicly said, and they haven't gone back on this, that if they find a case where AI was used to facilitate the fraud, that they would seek maximum penalties and sentences. You know, in other words, they don't want AI to be helping bad guys do things, commit fraud. And in fact, I will tell you, when we talked a few minutes ago about the takedown last June, where it was the biggest takedown ever, 22 of those cases alone were in the Southern District of Texas. There was one case that the government had where it was a DME case. It wasn't home health or hospice, but it's still instructive, where they had to have recordings of the patient saying, yes, I'd like for you to send that to my doctor and see if I can get this brace or whatever. It turns out that the recordings in their entirety were made up. It was all done by AI. And they talk about that. So, the government's very concerned, because if you've got fake patients and voices and the rest of it, I mean, apparently it's possible to say, here's the statement I want read, and I want it read by a 75-year-old white male, who has a back problem or something, and the computer can generate that statement in that fashion.
It's a brave new world.
Brave new world. Next slide. All right, here are a few cases, not a whole lot, but we have had some interesting matters here. two out of the Southern District and one out of San Antonio, you know. And the first one, the owner of a home health agency and individuals working at their direction, the defendant and the others, they cut out signatures and they taped them onto newly created doctor's orders, nursing notes, the rest of it. Well, obviously, you can't do that. That's pretty obvious, right?
Well, cutting and pasting is pretty easy to detect.
Yep. Okay, another one out of Southern District of Texas, out of Houston. They were 7 folks indicted. One of the defendants allegedly went to Medicare, Medicaid beneficiaries and their families and said that they qualified for hospice, even though they didn't. They weren't terminally ill. And one defendant paid kickbacks to group homeowners and others to help enroll patients, and to a hospital discharge coordinator. So, once again, it comes down to the government's looking at where you're getting your business from.
And once again, an interruption of the provider-patient relationship where somebody is incentivizing the creation of services instead of it just organically developing. And
this kind of reminds me too, with these marketers, if in fact you're paying a marketer as a 1099, they're a contractor, they're not a bona fide employee, and they're out there, and you have the same risk, I guess, even with employees though. If you were compensating them based on their success, based on their ability to generate referrals, you may not even know that they're engaging in wrongdoing by sharing some of the money with the nurse that gets the referrals from the doctor's office or the hospital coordinator or whoever it is. But I can pretty much guarantee you, when they're caught, and they will eventually get caught, the first thing they're going to say is, well, of course, I'm just doing this under the direction of the home health agency.
That's right. The government's always going to try and work up the food chain to get the top of the organization if they can.
So I guess my point is, you got to be very careful, because these folks are out there and they're conducting business and they're throwing your name around and your reputation as well. So you got to be careful. And then the San Antonio case, it was resolved under the False Claims Act civilly, but the physician was getting kickbacks from the hospice to certify patients as being eligible when in fact they weren't eligible. Next slide. All right. Now, let's get into some of the criminal issues that we've talked about with kickbacks, shall we, John?
All right.
All right, John. If we talk about medical directors, everybody on this phone call has medical directors, whether you're a home health or hospice, okay? If you're going to try to fit your medical directors, they're not employees probably. They're not going to be a bona fide employee. So the only way to actually compensate them would be under the safe harbor for personal services management contracts. But what are the rules? If you're going to try to pay a medical director, what are these basic rules under that agreement that they have to follow?
Well, it has to be in writing and signed by the parties. It's got to cover the services to be provided to the agency. The agreement has to be for at least a year. It's got to identify the compensation methodology in advance. It has to be consistent with the fair market value of those services provided. That goes back to where I was giving you the example of, well, if the fair market value for these services is $5,000, but it's a $20,000 per month contract, then that's going to be a red flag that it's not fair market value, and then it's by nature not going to be an arm's length transaction. It has to be determined in a manner that takes into account the value and volume.
That does not take into account. That's a typo there. We'll have to fix that before we send out the slides.
I was just misread. It says not determined.
Oh, not determined. There we go. So it's okay.
So not determined by value or volume. And then the aggregate services contracted don't exceed those that are reasonably necessary to accomplish what the reasonable business purpose of the service is to be. So the long and short of it is there are elements that need to be in these agreements. You're much better off making sure that your health lawyer helps you with those agreements and makes sure that they're in compliance so that you don't run into problems down the road.
And let me tell you where we've seen this leave the rails. A lot of times, medical directors are paid by the hour. And as long as that's in advance, and that's the compensation methodology. You don't have to know you're going to pay them a total of $15,000 over the next year. You could if you want to pay them a flat fee per month, okay? But most of the time we're seeing people are doing it by the hour, right? The problem is this. They will bill for so many hours at a fair market value, let's say of $250 an hour, okay? And 10 hours. When the government asks for copies of these contracts, they're also going to go in and they may issue a separate subpoena to the doctor to see, okay, well, they paid you for 10 hours. We want to see the documentation that you spent those 10 hours. What did you do during that time period? And the problem, of course, is doctors are the worst documentarians. So we're stuck in a situation where our home health or hospice client has been paying this doc on the average between $3,000 and $4,000 a month, but the doctor can't really document what he's done to get that check. And then, of course, the government assumes what?
Assumes that the services weren't provided.
And the only thing that really we're compensating the doctor for is referrals that he's sending to the home health or hospice.
Yeah, that the hourly submissions are a sham.
And that's why it's so important, guys, that it's great to you can have a beautiful, and John, you alluded to this a bunch of times, you can have a beautifully written contract, and you can go to a good health lawyer and they can work up a contract that on its face, that's great. But at the end of the day, if the doc doesn't do what he's supposed to do and actually document what he's doing to get those checks, okay, everybody's going to be in trouble. Next slide. Okay, marketers, same kind of stuff, guys. We got to watch out for. It's got to be, I say here refers to the IRS test. That's not necessarily true. Most of those elements are the same, but there is a specific Supreme Court case that actually lays out the requirements to qualify as a bona fide employee. So don't just rely on the IRS test, okay? But essentially, once again, they're looking at, how are you paying these people? I mean, are you paying them per hour? There's nothing wrong with having a marketer or whatever you're going to call them. Are you paying them per hour to drop off information at doctors' offices about your services? How are you paying them? Is it an hourly situation? If they are a bona fide employee, then you could pay them a salary and then still give them a bonus for their ability to generate referrals. But like I said, even if it meets the employee safe harbor, the government really does not like value or volume situations. They just don't. Next slide. Other things that we've got, look at your lease agreements, guys. Let's say you're a home health agency and you own the building and you have extra space and you like your medical director. He's a great guy. He sends you good business and he's a really good doctor. You could say, look, it's sitting here empty. Why don't you use this extra space? Well, you're giving it to him for free or for less than fair market value for the space, okay? The government's going to look at that as a disguised kickback. And then what about this last one down here? We've actually had these cases, haven't we? Where they, the home health or hospice, they give something of value just to say thank you. Whether it's a gift card or sporting event tickets or the rest of it.
Or an invitation up to the suite at the sporting event, which would go for far more than a normal ticket and far more than the value that you would think services would be worth.
The government doesn't like that stuff. They consider that to be evidence of a kickback. Okay. So what do you recommend, John? If someone finds out that they've got an investigation of their home health or hospice, and let's just say that, as in most of these investigations in Texas, a lot of times the government may be wrong, but they're looking at potential kickback liability.
Anytime there's an inquiry, of course, we're lawyers, but we really suggest that you contact a lawyer if there's an inquiry that might suggest that they're looking at wrongdoing. Because if you get an attorney involved in advance or early, then the attorney's going to understand, a healthcare attorney anyway, is going to understand what they're looking at, what the issues might be, and can help you take restorative action before problems arise. So it's that old commercial, for those of you old enough to remember it, with the Fram oil filter that, you can pay me now or pay me later, but it'd be a lot more efficient and effective if you contact your healthcare lawyer early to make sure that all of your documents are in order that support whatever your efforts were that the government may be examining.
Now, John, these folks are pretty cagey, though, aren't they? What if they come in and a couple of FBI folks show up and they want to talk to them, and you say, well, I need to call my lawyer. First thing they're going to say is, well, but we're not looking at you. We're really looking at one of these other folks over here. We just want to ask you a few questions.
Yeah, you never want to talk with law enforcement without a lawyer present. And I know that you want to look cooperative, and that you don't want to think that you have anything to hide, or don't want to give the impression that you have anything to hide. But the best answer is, boy, I absolutely want to give you all the information I can. I just want my lawyer here with me while I do it. So there's nothing wrong with that, and don't let them trick you into thinking that you don't need a lawyer if it's law enforcement. If it's just an audit, you don't need your lawyers there to talk to them. But you want to say, well, we need time to get our documents together. So, we'll contact our attorney to make sure that we're complying with your audit properly.
Sage advice, John, sage advice. And that's pretty much it for today, guys. The last thing I would tell you is, Texas hospices are under the gun. Be very careful. Home health and hospices, they face a greater risk of revocation today than ever before. And I would really suggest that if you, as John said earlier with law enforcement, at the first sign of any kind of administrative action, call your attorneys.
So it looks like we don't have any more questions.
Okay.
So I'm just end the webinar. So that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Robert and John. Everyone from today's webinar will receive copies of the presentation tomorrow via email. And if you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to the speakers or directly to Liles Parker. Have a good Wednesday and take care.
Thank you so much.
Thank you, everybody.